Good afternoon to those joining us in Dubai. Good morning to those joining us in London. I hope you can hear me. Thank you for joining us for another Beale & Company webinar. This webinar is the first in a series of webinars which look at managing legal risk in the Middle East. By way of introduction, I am Will Buckby, a partner at Beale & Company in our Projects and Contracts Advisory team. I am a registered legal consultant in Dubai and a qualified solicitor in England and Wales. Today I am joined by Natalie Ledger. Natalie is a solicitor in the Projects and Contracts Advisory team and also the Dispute Resolution team. Natalie grew up in the United Arab Emirates and prior to joining Beale & Company worked for other specialist construction firms in the UAE. Natalie and I are very pleased to have so many of you attending today's webinar. Before we start, and in our usual format, I would like to deal with the usual housekeeping items. This webinar is scheduled to last approximately 1 hour. During the webinar, you can submit questions to us in the appropriate box on the right-hand side of your screen. We will try to deal with these questions during the webinar or at the end if time permits. By way of a quick summary of what we aim to run through today, over the next hour, Natalie and I will provide an introduction to the issues shown on the slide. As this is the first webinar in a series of webinars on managing legal risk in the Middle East, this is a high-level introduction to the issues on the slide. So the issues we are going to discuss today are the UAE legal system and civil code, freedom to contract and contract formation, contract interpretation and performance, duties under contracts, limitation clauses, decennial liability, limitation periods, damages under UAE law, dispute resolution, including the local courts and arbitration, and enforcement and recovery. There is a lot to get through. In summary, we will start with some basic legal principles under UAE law. We will then deal with some front-end considerations, and at the end of the webinar discuss some back-end dispute issues. It is important to mention that the above issues will be discussed in relation to the laws of the UAE generally and will not cover any of the laws of the various free zone areas in the UAE. Most of you will understand what I mean by free zone area. Beale & Company's office is in a free zone, the Dubai International Financial Centre, or the DIFC. Free zone areas are geographical areas located within the UAE in which companies can be established. Each free zone area focuses on different business sectors such as media, commodities and finance, for example. There are various benefits to establishing a company within a free zone area rather than the UAE generally. Typically, this will include 100% foreign ownership and various tax exemptions. To varying degrees, free zones have their own laws and/or regulations. So following that introduction, I'm now going to hand you over to Natalie, who's going to deal with the first topic and introduce the UAE legal system and civil code.
Thank you, Will. In this section, as Will says, I'll provide a brief overview of the UAE legal system and some of the key issues to consider when contracting in the UAE. Some of my comments are very high level, but nevertheless provide important background to understanding the legal framework in the UAE. The UAE Constitution provides that Islamic law, Sharia, is the guiding principle in the formulation of all legislation passed in the UAE. Sharia law is the law of Islam and is derived from the Holy Quran and the Sunnah. The UAE legal system is based on the civil law model, meaning that the law is codified. In other words, every law is prescriptively set out. The aim of this model is to put in place a comprehensive set of laws that cover all eventualities. In the UAE, this consists of the federal laws of the UAE, which apply to all 7 emirates of the UAE, and the local laws and regulations of the relevant emirate, which are unique to the emirate. It is therefore important to bear in mind that some laws may vary from emirate to emirate. For example, Abu Dhabi and Dubai have their own standalone procurement laws applicable to tenders issued by local authorities. Generally, however, local procurement laws are substantially similar to the federal procurement law. Both federal and local laws govern the UAE construction industry. The most relevant of these laws is Federal Law No. 5 of 1985, the Civil Code, which contains a considerable number of provisions that govern construction contracts. There are various other federal laws and local laws that apply to the UAE construction industry, as well as numerous regulations. For example, there are standard specifications for imported construction materials and products, health and safety regulations, and environmental regulations. An important difference between civil law systems like the UAE and common law systems is that there is no principle of binding precedent. This is an important distinction and means that common law principles, which are likely to be familiar to those of you working in the UK construction industry, for example, may not apply under UAE law. Another important difference is that terminology adopted in standard form construction contracts, which have often been drafted and developed for use in common law jurisdictions, may not have the same meaning or effect under UAE law. One cannot assume that commonplace terminology, which has a well-established meaning in common law jurisdictions, will have the same meaning under UAE law. A good example is the understanding of the term condition precedent. Under English law, a condition precedent relates to an event which must occur before performance under a contract becomes due and any contractual duty exists. However, in the UAE, the courts tend to apply this term less stringently. For example, the courts are less unlikely to disregard a claim brought by a party who has failed to satisfy a condition precedent if the court believes there is some merit to the party's claim. Given that construction contracts in the UAE are typically governed by UAE law, and where they are not governed by UAE law, mandatory legal principles will apply in any event. It is important that when considering contractual issues in the UAE that one keeps this difference in mind, as it can have a significant impact on your rights, obligations, and liabilities in practice. The UAE Civil Code sets out its contract law, dealing with, amongst other things, the principle of freedom to contract, the formation of contracts, and an individual's authority to bind a company to a contract. Article 257 of the Civil Code provides that the basic principle in contracts is the consent of the contracting parties and that which they have undertaken to do in the contract. As such, parties are generally free to agree the terms that govern their contractual relationship. As the principle of freedom of contract applies to both the substance as well as the form of contract, if a term has been agreed in a contract, the local courts or tribunal will generally uphold and enforce that term. Therefore, and it goes without saying, that it is important that the terms of the contract are fully understood prior to entering into it. However, a party's freedom to contract is restricted by a number of provisions of UAE law. These range from fairly commonplace restrictions that are found internationally, such as the requirement that the contractual term will only be enforceable to the extent that they do not conflict with public policy or decency, to much more specific requirements, such as the unenforceability of a contractual term due to conflict with mandatory provisions of law. Will and I discussed some of these in the webinar. As in common law jurisdictions, the Civil Code provides that the fundamental requirements for any contract, including, of course, construction contracts, are that they are made up of an offer and an acceptance. This is Article 130. In addition, Article 129 of the Civil Code provides that the essential elements of the contract must be agreed, the subject matter must be adequately defined, and there must be a lawful purpose to the contract. The Civil Code provides further mandatory provisions that apply to contracts for works and services, including construction contracts. These are called Mukawala contracts, and they are dealt with in Article 872 to 896 of the Civil Code. Amongst other things, these provisions provide that a valid and binding construction contract should contain a clear description of the subject matter of the contract, details of the works to be carried out, the time and manner of performance, and the contract price. Whilst there is no express requirement for a construction contract to be in writing, UAE law permits oral contracts. However, it is less likely that a party would be able to satisfy these requirements if the contract were not in writing. It is, of course, in any event, good practice to enter into a written contract to avoid any uncertainty which could encourage a dispute. In terms of a letter of intent, in order to have contractual effect, any such letter of intent must satisfy the basic requirements that we have just discussed in respect of construction contracts. The UAE courts will give effect to a letter of intent if such requirements are satisfied. Where no formal written contract is entered into, or to the extent that a contract is silent on a particular issue, the court or tribunal will seek to find that a contract exists, the terms of which will be governed by the laws of UAE in descending order of priority. 2. Relevant federal laws, local laws, construction industry custom, and custom generally, in order to make the contract work. There are some very important considerations in relation to one's authority to bind a company under UAE law. As in most jurisdictions, when entering into a contract, it is important to check that whoever will be signing the contract on behalf of the parties has authority to do so. Article 103 of Federal Law No. 8 of 1984, the Commercial Companies Law, provides, and reading from the slide, the Board of Directors shall assume all the powers necessary to execute the businesses required in satisfaction of the company objectives, save such powers as may be vested by the law or the company articles of association in the General Assembly. However, it is not permitted for the Board of Directors to enter into loan agreements whose term exceeds 3 years, nor to dispose of the company properties or place of business, or to mortgage the same, release company debtors from their commitments, consign or refer to arbitration, unless the same are expressly granted by the company articles of association or embodied by nature thereof in the company objectives. And other than those 2 cases, it is a condition for the conclusion of such actions to obtain the approval of the General Assembly. Therefore, a director's authority to bind a company may be limited in scope, either by law or in the company's constitutional documents. One of the most important effects of Article 103 of the Commercial Companies Law is that, unless special authority is provided to an individual by the company, that individual will be unable to bind a company to an arbitration agreement, meaning that proceedings will need to take place in the local courts. As such, if a signatory to a standalone arbitration agreement or a contract which contains an arbitration agreement or clause does not possess the requisite authority to bind the entity, the arbitration agreement will be invalid. Article 2A3(4) of Federal Law No. 11 of 1992, the Civil Procedure Code, supports this position, providing that an agreement to arbitrate shall not be valid unless made by persons having the legal capacity to make a disposition over the subject matter of the dispute. And Article 58 of the Civil Procedure Code expands on this. Accordingly, Articles 105 of the Commercial Companies Law and Articles 58 and Articles 203(4) of the Civil Procedure Code require that an arbitration agreement, the effect of which is to waive a party's right to bring proceedings before the UAE courts, can only be made by persons with the authority to do so. This is a typical issue which our clients often come across, and as such, we recommend that internal protocols and procedures are put in place to ensure that parties do not fall foul of these articles. Practical considerations for those of you entering into contracts in the UAE are to ensure that the individuals signing the contract on behalf of the other party have the authority to enter into the terms being agreed on behalf of that party. For example, request documentation evidencing this. To ensure that the individuals entering into the contract on behalf of your own organisation have the requisite authority to enter into the terms being agreed. When interpreting the meaning and effect of contractual terms under UAE law, Article 258 of the Civil Code provides, the criterion in the construction of contracts is intentions and meanings and not words and form. Therefore, federal law provides that words should have their true meaning and other meanings should not be applied unless it is impossible to apply the words literally. To reinforce the point, the Civil Code includes two other provisions of particular importance that are relevant to the interpretation of a contract. Article 259 states that there shall be no scope for implications in the face of clear words, and Article 260 states words should be given effect to rather than be ignored, but if it is impossible to give effect to words, they shall be ignored. It has been said that the provisions of Article 258, 259 and 260 of the Civil Code are potentially confusing. However, the courts appear to have no difficulty with them. As a result, when determining the meaning and effect of contracts, the main consideration of the UAE courts is one of intentions and meanings, not words and form. Where it is arguable that the terms of the contract are unclear or ambiguous, a court or tribunal does have discretion to look behind the terms of the contract in order to assess the intentions of the parties. The court is, however, unlikely to fix a bad bargain. One of the important obligations imposed on the parties to a contract by UAE law, and something that parties should keep in mind when performing a contract, is the implied duty of good faith. Article 246 of the Civil Code states, the contract must be performed in accordance with its contents and in a manner consistent with the requirements of good faith. What this means, in effect, is that the parties must not use the terms of a contract to abuse the rights of the other contracting party, not to cause unjustified damage to the other party, and to act reasonably and moderately. The Dubai courts have ruled that an act of bad faith by one contracting party may provide a cause of action for the other, and the duty of good faith is therefore overarching, unlike English law. In deciding whether an act constitutes bad faith, the court may also look at Article 106 of the Civil Code, which provides that a party is prohibited from exercising its rights if it is intended to infringe the rights of another party, the outcome is contrary to the rules of Sharia, the law, public order or morals, the desired gain is disproportionate to the harm that will be suffered by the other party, or it exceeds the bounds of custom or practice. There are some potentially wide-ranging consequences of this, and contractual terms may, in effect, be set aside or adjusted when one party is culpable of a breach of good faith. A good example of this is in respect of the employer's attempted reliance on a time-bound notice, as seen in subclause 20.1 of the FIDIC suite of contracts, and that such reliance may well be restricted where a party seeking to rely on it knew of the circumstances giving rise to the claim previously. For example, if a contractor is delayed in completing the works causing critical delay to a project due to an employer's failure to pay an interim payment within the time required by the contract, and although his inability to progress the works is discussed with the employer and engineer, no formal notice is submitted under the contract within the time required. In this situation, it could be argued that the employer's denial of the claim merely on the basis of a failure to formally submit the claim under the contract is a breach of the employer's obligation of good faith owed to the contractor. In respect of unfair contract terms, Article 2662 of the Civil Code provides that, nevertheless, it shall not be permissible to construe ambiguous words in contracts of adhesion in a manner detrimental to the interests of the adhering party. This is a mandatory provision and cannot be excluded by the parties. However, its application is restricted to contracts made by way of adhesion, which effectively means those where there is significant inequality between the bargaining positions of the parties and limited scope for negotiation of the applicable provisions. It will be interesting to see how this provision may be applied over the coming years, given the terms which we have seen contracting parties are being asked to enter into by employers. I'm now going to pass you back to Will, who will talk through standard of care under UAE law.
Thank you, Natalie. The Dubai Civil Code contains various provisions governing a party's obligations. In a construction context, Article 3831 of the Civil Code is very relevant to one's obligations under their contract. It provides, if that which is required of an obligor in the management of a thing or the exercise of care in the performance of his obligation, he shall have discharged that obligation if, in the performance thereof, he exercises all such care as the ordinary man would exercise, unless there is an agreement or provision of law to the contrary. It follows from Article 3831 of the Civil Code that consultants or contractors' obligations might be limited to a reasonable efforts level when assessing compliance. However, this is of course subject to agreement between the parties. In practice, absolute or strict obligations exist in consultancy agreements and construction contracts, thereby overriding this principle. In addition to absolute or strict obligations, in an increasing number of instances we're seeing fitness for purpose obligations in consultancy agreements and building contracts. This is obviously a concern for consultants and contractors, as the losses arising out of a breach of fitness for purpose obligation are not typically covered by professional indemnity insurance. Where an agreement does not contain fitness for purpose obligations, the general view is that fitness for purpose obligations will not be implied into an engagement under UAE law. You'll be pleased to know that clauses that limit a party's liability are enforceable under UAE law. Article 390 of the Civil Code provides that the contracting parties may fix or restrict the amount of compensation in advance by making a provision therefor in the contract or in a subsequent agreement, subject to the provisions of the law. However, importantly, there are a number of exceptions to this rule. These are in respect of the concept of decennial liability, because the court has an entitlement to open up a pre-agreed limit of liability, and in circumstances where there has been gross negligence, intentional harm, or fraud. The first exception, decennial liability. Under Article 880 of the Civil Code, there is a strict decennial liability period for construction projects. However, there is more to it than this. By this article, the designer and the contractor are jointly and severally liable for 10 years from the delivery of the project for the total or partial demolition of construction works or other permanent works, and any defect which threatens the stability or safety of the work. This is a very onerous obligation and difficult for those used to common law jurisdictions to understand. For our consultant clients, your liability will depend on your scope. For example, and very broadly speaking, where the consultant produces the design and supervises the works, he or she shall be jointly liable for both structural defects and design defects. Where the consultant produces the design without supervising the works, he or she shall be jointly liable for the design defects. Parties cannot contract out of decennial liability. Generally, you can only deny liability on the basis of a force majeure or the employer's fault, and the burden of proving these events is very heavily on the consultant and contractor. A further exception is pursuant to clause Article 390 of the Civil Code. The UAE courts, including arbitral tribunals, are afforded a wide discretion to vary or open up limitation clauses. Article 390 of the Civil Code provides that, upon application by a party to a contract, judges or arbitrators can vary limitation clauses by increasing or decreasing the amount of compensation to reflect the actual loss suffered. A final exception is in relation to losses arising out of gross negligence, intentional harm or fraud. Gross negligence as a concept is not recognised under English law, although it is more typically recognised in other jurisdictions. The courts have confirmed that limitation clauses cannot apply to losses arising out of gross negligence, intentional harm or fraud. Case references are provided on the slide. These last slides have been dealing with limits of liability in contracts. It is worth highlighting that under UAE law, where there is no contractual relationship between two parties and one party breaches a duty or obligation imposed by law and a tortious claim arises, Article 296 of the Civil Code prohibits any limit or exemption of liability in respect of tortious claims. This is consistent with most common law jurisdictions. So to wrap up limits of liability, it is our view that limit of liability clauses in most cases will be enforced by courts and arbitral tribunals. However, there are circumstances where such clauses will be opened up. From a front-end contract drafting point of view, in practice, consultants and contractors should not assume that they can achieve limits of liability clauses in their appointments when negotiating these with their clients. From our experience, save probably in respect of liquidated damages, it is not unusual for professional appointments and building contracts to omit limitation clauses. And the take it or leave it approach to contracting in the region means that negotiating such clauses can be very difficult. From our experience, our clients are entering into contracts without limits of liability. Moving on to limitation periods, notwithstanding the Sharia principle that a just claim never expires, federal and local laws impose limits on the time in which a claim can be commenced, dependent on the type of claim being made. Therefore, to avoid a claim being time barred, it is important to be aware of the relevant limitation periods. As in common law jurisdictions, limitation periods begin either when a cause of action is deemed to have arisen, such as a breach of contract, or when the harmed party becomes aware of the harm. I have included a summary of the key time periods on the slide in front of you to be used as general guidance. The Civil Code sets out some general rules relating to limitation periods. However, there are quite a few exceptions set out in the Civil Code itself and also in the Commercial Code. Amongst other things, you will see that as a general rule, a contractual claim is time barred after 15 years unless a specific provision states otherwise. I'm now going to touch upon damages under UAE law. As a starting point, Article 389 of the Civil Code provides, if the amount of compensation is not fixed by law or by the contract, the judge shall assess it in amount equivalent to the damages in fact suffered. To develop the concept of damages further, where there is a contractual relationship between the parties, UAE law recognises the concept of direct damages, interest, damages in respect of loss of opportunity and loss of profit, and moral damages. Such losses must arise directly from the relevant breach and have been foreseen by the contracting parties as at the date of the contract or contracting. In relation to tortious claims, the same heads of losses are recoverable, plus consequential losses. There are some clear differences here to, say, damages under English law. In our view, liquidated damages clauses are widely used in construction contracts in the Middle East. In the UAE, it is commonplace for consultants and contractors to agree to liquidated damages provisions. As I've noted already, Article 390 of the Civil Code provides that the contracting parties may fix the amount of compensation in advance by making a provision, therefore, in the contract. Article 390 also states that the judge may, in all cases, upon the application of either of the parties, vary such agreement so as to make the compensation equal to the loss, and any agreement to the contrary shall be void. This gives the court the ultimate right, upon the application of the parties, to examine the level of pre-agreed fixed compensation and increase or decrease the amount to reflect the actual loss suffered by a party. So what actually happens in practice? Well, recent cases have shown that something referred to as a penalty, being a more strict imposition of an amount regardless of whether a loss has been incurred, may not be upheld by a court, whereas a liquidated damages clause intended to reasonably quantify the loss likely suffered is more likely to be upheld. We currently have a number of arbitrations in the office which involve a claim by the employer with respect of liquidated damages on the basis that a contractor has failed to complete the works within the time required by the contract. In more than one instance, there is a corresponding claim seeking to limit the damages which the employer is seeking to recover pursuant to Article 390 on the basis that the damages which the contract provides for exceeds the damages actually suffered by the employer as a result of the delay. This is a common fight in the UAE. Now very briefly dealing with interest. Under Islamic law, interest was traditionally forbidden. However, the courts in the UAE now recognise and enforce, at least to some extent, and subject in certain cases to a cap on the rate that may be charged, contractual interest provisions. And the courts will typically apply statutory rates of interest for debts and late payments when no contractual rate is specified. Some examples. Article 88 of the Commercial Code states that if the subject of a commercial obligation is a sum of money in an amount known at the time the obligation arose and the debtor delays in making settlement, he shall be bound to pay the creditor the interest specified in Articles 76 and 77 as compensation for the delay unless otherwise agreed. In addition, the Dubai courts have recently established that a delay penalty of 9% may be added to civil debts unless the parties have agreed otherwise. Therefore, it is clear that UAE law allows interest, and a debtor is required to pay interest as compensation for the delay in settling the debt due. I'm now going to pass you back to Natalie, who will provide an overview of dispute resolution in the UAE, followed by enforcement and recovery.
Thank you, Will. Construction contracts in the UAE generally contain either a litigation or, more commonly, an arbitration clause. There is no arbitration law in the UAE, thus both local court proceedings and arbitrations, excluding those being heard in the DIFC, are governed by the civil laws of the UAE. The civil court structure is a three-tier one, comprising the Court of First Instance, the Court of Appeal, and the Court of Cassation. These courts hear all commercial cases, including construction claims, and there are no specialist courts like the Technology and Construction Court in the UK. As previously mentioned, under civil law, there is no concept of binding precedent, and consequently, the judgments of the higher courts are not binding on the lower courts, and each case is decided upon its own merits and facts. Court proceedings must be in Arabic, and all non-Arabic documents filed at court must be officially translated into Arabic. This can be both a timely and costly exercise. Court proceedings also often involve several rounds of submissions and hearings, and the possibility of multiple appeal and ancillary proceedings. Generally, a successful party will have to bear its own legal expenses, and therefore, in many cases, is not cost-effective to pursue small claims through the courts. Only Arabic, usually Emirati, speaking advocates are licensed to appear and have rights of audience. All civil matters are based on written pleadings of the parties, supported by documentary evidence. In general, there is no oral hearing in civil cases, and it is common for the court to rely on court-appointed experts. Court-appointed experts typically have a civil law background and may not possess the specialist knowledge relevant to the matter in dispute. The final decision in any case is at the discretion of the judge hearing the case. There is, therefore, a high level of uncertainty in predicting the outcome of court proceedings. For these reasons, construction contracts, particularly those involving international parties, frequently provide for arbitration as the agreed method of dispute resolution. Arbitration proceedings in the region are commonly subject to local rules of the Dubai International Arbitration Centre, DIAC, or the international rules of the International Chamber of Commerce, the ICC. Arbitrations can also be heard in the Arbitration Mediation Centre in the DIFC and are likely to be subject to the DIFC LCIA rules. Arbitrations in Dubai can be conducted in English. International lawyers, including firms such as ours, can appear and have rights of audience and arbitral hearing. Oral evidence is permitted, and the parties can appoint experts and arbitrators who have a common law background, if preferable given the circumstances, and the relevant specialist knowledge. It is generally considered that parties will be better off seeking to have their disputes resolved by way of arbitration than the local courts. One important point to note is that in the Emirate of Dubai, express permission to commence arbitration proceedings against the government or a government entity must first be obtained in advance from the Legal Affairs Department prior to proceedings being commenced. Despite the advantages of arbitration over the local courts, historically, parties preferred litigation over arbitration as an element of uncertainty was considered to surround enforcement of arbitrary awards. For example, it was not uncommon for courts to refuse to ratify an arbitration award for minor formalities, such as one of the members of the tribunal failing to sign one of the pages of the arbitration award. Although a degree of uncertainty in enforcement still prevails, the local courts are becoming more familiar with the arbitration process and more willing to recognise and enforce arbitration awards. This has been assisted by the establishment of DIAC in 1994 and the introduction of the DIFC LCIA Arbitration Centre in 2008. Recent developments in arbitration rules and procedures, the promise of an arbitration law, although this has been under consideration for some time now, and the court's welcoming approach to the New York Convention, which the UAE signed up to in 2006, all show signs of the upward trend in the UAE, in the use of arbitration in the UAE. In respect of recovery in general, the UAE has relatively unsophisticated regimes for the tracing of funds and do not restrict the transfer of assets, where a company or individual is the subject of legal proceedings to the extent that is possible in common law jurisdictions such as the UK. Therefore, claimants, even if successful, may find the counterparty against whom they are seeking enforcement of a court judgment or arbitrary award has transferred its assets to another entity during the course of proceedings. I shall now pass you back to Will.
Thank you, Natalie. So that was a whistle-stop tour of some of the legal issues arising in the UAE construction industry. In making some concluding remarks, the legal framework in the UAE as a civil code jurisdiction is very different to the common law approach to life to which we know in, say, the UK. This must be borne in mind. Further, whilst there are some significant opportunities in the UAE, the opportunities go hand in hand with the risks arising. For instance, construction contracts are significantly more onerous than those entered into, say, the UK. By understanding those risks and mitigating them where possible, you will hopefully be able to get paid on time and to avoid disputes. That now concludes our webinar on legal risks arising in the UAE construction industry. Thank you very much indeed for listening, and I hope you did not experience any sound difficulties. I note we've received a number of helpful questions. Thank you for these. Natalie and I have answered some of these by responding to you directly during the course of the webinar. For those questions we have not answered, we will write to you or call you separately with a response. As with all our webinars, this session has been recorded. We will circulate the recording along with the slides to you shortly. Please feel free to circulate these amongst your colleagues. Before we finish, please note there will be another webinar in this series in the summer. This webinar will be led by Claire Miller of our Dubai office and focus on legal risks for contractors. It remains for me to say thank you for listening to me and Natalie this afternoon. If you have any queries in relation to any of the items we've discussed or on UAE law, please do not hesitate to contact us on the details shown on this screen. Please also feel free to pop into our office in Index Tower in the DIFC. Details are on the slide. Once again, thank you for listening.